So that then is the sketch, very sketchy, vague, gestural, of an ideal of criminal law. Again, not the imperative voice of the sovereign saying, do this or else, but the voice in which we speak to each other of our own shared values, of the central values which define our civic life together. A voice in which we define the wrongs that count as public wrongs, wrongs that matter to us all in virtue of our citizenship. These wrongs are our collective business. But also the way in which we respond appropriately to commissions of those wrongs, the way in which we call each other to account, and are called to account by our fellows for our wrongdoing. That seems to be the core of criminal law as an appropriate way in which citizens can address each other and themselves and can deal with and recognize the wrongdoings which violate their civic community. And I think that is, I hope you'll agree, it is a plausible ideal of what criminal law aspires to be as a law for citizens. What's also true, though, is that law, as thus understood, makes exacting demands not just on those who are subject to its attentions as defendants or offenders, but on all those citizens whose law it is meant to be. Because if it's our law, then it's up to us to make sure that it functions as indeed our law. And what I want to do now is talk about the demands that kind of view makes on us, the challenges it poses to us if we try to make the law really what it aspires to be as a law fit for citizens. Some of these demands are internal to criminal law and its operations. I mentioned three of them here. First of all, the law's content. What the law must do is to define a class of wrongs which can be recognized by all citizens as public wrongs. They're not as wrongs, but wrongs which are the business of all citizens. The law must aspire to do that. And how can that be achieved? We need here some kind of public deliberation which will work out collectively the scope, the content of our public shared morality. And that's already a major task. It's an especially difficult task in polities like most of our own, which are in some sense rather multicultural, which involve a variety of different groups with different beliefs, traditions and ways of life. But it's still which aspire to live together still as something other than groups of strangers living next to each other. What kind of criminal law can be possible for a multicultural polity? Because, of course, the danger is, as always, that the dominant group will say, these are our values, and the our now is that group. And you, would be the immigrants, you, the minority group, must accept our values. But that's not a language of inclusion, that's a language of oppression. If we're to be serious about citizenship, then we must ask what kind of process we can undertake of public deliberation, which will produce genuinely shared values. We can all say, whether we now as all citizens, yes, these are our values, which we recognize as ours. That's one challenge for criminal law, is to find a way, or for us as citizens, to find a way to work towards articulating a set of shared public values, which are genuinely our values as citizens, where the our now is an inclusive our, not the our of a small dominant group. To work out, A, what we must agree is wrong, and B, what we must agree count as public wrongs, not merely private matters. That's the first challenge. Second challenge, the criminal process. I told you the story about the trial as a process of calling to account. The defendant's called to answer for his conduct in the public forum. Look at our actual courts, what goes on in our actual courts. That's not what's going on. Our courts are a conveyor belt which deals with a whole range of defendants. Most of them have no clue what's going on. They're processed through the court. The lawyers tell them what to do. In they go to court. They're told they're guilty, punished, off they go. There's no real process of being called to account in most of our criminal trials, in most of our actual courts. So the challenge to make the law's aspirations real is a challenge to make the trial a process which does call the defendant to answer, which enables them to answer. First of all, can they understand what's going on? Can they understand the process as a process which calls them to answer a charge of wrongdoing? Often not. How can we make sure they do understand? Are they treated as participants? Again, if you read what's said by defendants and also by victims, they're there as passive observers, if they're lucky. They don't feel part of the process. There are things being done to them, things said about them by the court, the judges, the lawyers. What's important on this view is that the defendant is an active participant in the trial. He's there to answer the charge. We need a process which makes it possible, which helps the defendant play that active role. Which of course means also he must be able to view the court with some respect as a forum in which he's called to answer by his fellows. Well, okay, how are defendants treated by the police in advance of trial? How are they treated by the prosecution service and so on? Are they treated in ways which make it possible for them to respect the court as the voice of their fellows calling them to account? Again, I think the ideal of what criminal law aspires to be is a very long way from the actuality of many of our courts and our court proceedings. I note also in passing, there are also issues about the role of the victims to play in all this. The prosecution takes over the case from the victim. I was mugged, I was assaulted, I was attacked, but then the case is taken over by the police, the prosecution, and they try the case. So the case is now not me against the offender, the case is now we, the people, try the offender on the victim's behalf, as it were. But in some sense, I must still better recognise, in some sense, that it's my case going through the court. It's my wrong being recognised. So how far can victims see that as addressing their wrong? That's one issue about the role of victims and how far the court, the process, addresses them appropriately. But also, again, bearing in mind that a civic criminal law makes us all active participants in the process. What's the active role for victims? What is their role in the process? How far do they have a responsibility as victims, as citizens, to take part in the process, to bear witness to what they suffered? So questions about the offender's role are salient, but also we must ask about the victim's role in the criminal process, what role they should play and how they can be enabled to play that role. Thirdly, back to punishment. Can we find modes of punishment which are consistent with citizenship? Can we find punishments which we can impose on each other while still recognising each other as citizens? I said before, that's the challenge which we face. An important question here is about what punishment means. If we punish a person, if we fine them or imprison them or require them to undertake community service, what are we saying to them? What's the message of their punishment? So again, often the message, in fact, is exclusion. You're pushed away into prison. You're pushed out from community into the prison for 5, 10 years. Also, then thereafter, you're allowed to suffer exclusion as well. So often punishment, in fact, operates in an exclusionary way. Its tones are those of exclusion rather than inclusion. The offender is the enemy, the outsider, the other against whom we, the law-abiding, must protect ourselves. That's how things, in fact, often go. The question is that how punishment has to be? Can punishment be other than exclusionary? And it seems to me that if punishment is operated purely as deterrent, or purely as a mode of incapacitation, then it is not treating the person as a citizen. Punishment as deterrent is back to Bentham. Do this or else. The or else is the big stick threatening you with suffering unless you obey. That's not the language of citizenship. That's the language of coercion, of duress. Incapacitation will lock you up to stop you committing crimes because you're now the dangerous outsider to be confined, cabined to protect us against you. So punishment as deterrence or incapacitation is exclusionary in its message. It's not a way of treating others as citizens. You treat them as ex-citizens, as outsiders. My own view is that punishment can be shown to be consistent with, indeed, an expression of citizenship, if we see punishment as a mode of communication. The trial itself is a mode of communication. We address the offender through the trial, saying then, look what you've done. Recognise the wrong you committed. Punishment, I think, can best make sense, moral sense, if that continues the communication. And we're trying to confront the offender with their wrongdoing and a way of making reparation for the wrongdoing through undergoing punishment. That's the best a wave towards a whole further story. But again, the challenge is there. Can we make punishment consistent with citizenship? Can we as citizens impose punishment on each other while still seeing each other as members of the normative community? In fact, we often fail to do that. Punishment, in fact, is typically exclusionary. But must that be so? Is that inevitable, or is that our own failure to see what punishment could be and make it what it could be? So those are challenges within criminal law, to make criminal law itself, in its content, its procedures, its punishments, something which citizens could impose on each other and to which they could subject themselves as citizens. But there are further challenges, and here's where I will end, which go beyond the criminal law itself and concern the context in which law operates. Here's one, which I again would need to mention rather briefly. If punishment is to treat us as citizens, it must be limited. You pay your fine, you serve your time in jail, and that's then the end of it. You've paid your debt, as the rhetoric has it. You're now released back into ordinary civic community. You're restored, okay, perhaps you are not restored to your intimate relationship. You might have lost your friendships or your marriage. That's not the business of the state. The business of the state is how you're now once again recognized as a fellow citizen in good standing because you've paid your penal debt. That's an important part of the rhetoric of punishment as something which is a matter of justice and which is limited in its scope. You aren't punished forever. Punishment comes to an end. But what does that mean? Again, if you ask what happens to ex-offenders, are they readmitted to the warm embrace of the civic community? Often not. So how can we make sure that punishment is, in substance as well as in name, limited? Those who've punished have indeed are recognised as having paid their debt. But the further question is, how clean is the slate? We talk of wiping the slate clean by undergoing punishment. You've paid your debt. You're now going to go back with a clean slate. But can that be true? Doesn't mean it's as if you never committed the crime. Well, surely not. You know, think of the fraudster who opens one company after another. They find a company, defraud their clients, off they go. Another one. They get caught, back they go again. The fraudster who repeats their fraud constantly. Can we say to someone, look, if that's what you've done, we can now disqualify you from operating certain kinds of business, from operating in the financial sphere. The doctor who's committed criminal offences as a doctor consistently, I say, look, have you served your term, back you go and practice medicine again. To some extent, surely, what you've done, the wrongs you committed, do justify us in taking special measures to disqualify you from certain kinds of activity which others can engage in. So a general question, which, again, is a challenge we face in two parts. Part one, what is it to have paid your debt? And how can we treat others as having paid their debts in substance, not just in rhetoric? But also, in what ways can we, without denying citizenship, still subject the ex-offender to certain kinds of special restriction which others don't suffer? But finally, we can give the even deeper challenge is this. It's commonly said, and truly said, that many of those who appear in our courts charged with criminal offences, who are indeed guilty of criminal offences, appear there against a background of various kinds of systematic injustice that they've suffered and the groups they belong to have suffered. They've been through their lives excluded from many of the benefits of citizenship, education, welfare, other kinds of support, from participation in political life. They appear as defendants and they appear as those who have suffered not just disadvantage but injustice of a systematic social kind. When that's true, we should feel uneasy about punishing them. The social injustice they suffer seems to undercut the legitimacy of the punishment they now suffer within the penal system. What explains that unease? One approach is to say, look, that kind of background social injustice provides a defence against the charge they now face. Because they suffered injustice, we can't now blame them. They aren't now blameworthy for what they have done. They're justified in fighting back against the system, or they're excused because their crime reflected the social pressures they themselves were under. Well, that's often implausible as a defence, partly because the crimes they commit are often crimes against those who are equally disadvantaged. And the real cause of their unease lies elsewhere. It's about our standing collectively to call them to account for what they have done. Take the personal case. Supposing I call you to account for some wrong you've done to me. You've let me down. You've broken a promise to me. You promised to meet me. You promised to do something and you didn't do it. And I call you. I say, how could you let me down like that? How dare you? Well, look, you say, that's how you behave towards me all the time. Every week you break a promise to me. how can you not blame me for breaking a promise to you? That kind of move. When I charge you with wrongdoing towards me, you say, but look how you treated me. That's a familiar kind of moral move, which has a lot of force to it. But what force did it have? When you say, look how you treated me, and you're not saying, look, therefore I was justified. My lying to you, my letting you down, doesn't justify you letting me down, nor excuse it. It's still true that you did wrong. What my conduct does is to undercut my right to call you to account. If I behave badly towards you, I'm ill-placed to condemn you for behaving badly towards me. So prior misconduct on the part of the would-be blamer undercuts his right, his standing, to call the other person to account for what they have done. And that seems a familiar feature of moral life, that our standing to blame, to call to account, depends in part upon our own prior dealings with the person we're dealing with. If I behave badly towards you, I'm now ill-placed to call you to account for behaving badly towards me. In the same way, then, in the criminal law, the person who suffered serious injustice in the past has not been treated by us as a citizen. They've not received the concern, the respect due to them as a fellow. The person whom we have failed to support, the person whom we have denied, if only passively, education or welfare or participation, we're not treated them as a citizen. But suddenly now, so you're a citizen, you're a fellow, we're going to call you to account as our fellow of what you've done. But come on, look how you've treated me before. You've not treated me until now as a citizen. You can't now start calling me to account as a fellow because you've not treated me as a fellow. So our own prior collective misconduct towards the person, the injustice they've suffered at our collective hands, albeit passively, doesn't justify their conduct or excuse it. It undercuts our right now to call them to account as our fellow, when we failed ourselves to treat them as our fellow up until now. So the real cause of the unease, the real source of the unease about trying those who suffered serious injustice at our hands, is not that perhaps they were justified, but about our standing to call them to account, given our own failure so far to treat them with the respect and concern due to them. But what follows? We can't just say, well, in that case, we can't try you, we can't condemn you, away you go. We can't just ignore the wrong. Partly because, of course, there will always, often be a victim whose wrong must be addressed. A victim often even worse off or as badly off as the defendant. So surely we owe it to the victim still to call the perpetrator to account, even though our standing itself is undermined by our own failures of justice in the past. What we need to recognize here is an important feature of responsibility. It's always a two-way reciprocal relationship. If I answer to you, you answer to me. If I call you to answer to me, I must also be willing to answer to you. It's always a two-way street. It's reciprocal. And the key point in the moral case, when I call you to account for lying to me or letting me down, what undermines my standing is not the mere fact of my own past misconduct towards you, but my own refusal now to answer for it to you. So again, I say, look, how could you let me down like that? You reply, but look, that's just what you did to me last week. How do I respond? If I say, look, that's irrelevant, I didn't answer to you, then my standing is undermined. I can't now require you to answer to me if I refuse to answer to you. But instead, suppose I say, gosh, yes, you're right. I hadn't thought about that. And you see now, yes, I really did treat you badly. If I'm willing now to answer to you for my conduct towards you, I can also now demand that you answer to me for your conduct towards me. So what undermines standing is an attempt to make it a one-way matter. If I demand that you answer to me but refuse to answer to you, that's what's improper. If I'm willing to answer to you for what I've treated you, then I can also ask you to answer to me. So once we build in the reciprocity of responsibility, we can also then restore our standing to call to account if we're willing ourselves to be called to account. And that then applies to the criminal case as well. What matters is that we recognize collectively that this person has suffered injustice, and we must answer to him for our own failure to treat him as a fellow in the past. That's what's crucial, to restore our standing to call him to account now, that we answer to him as we ask him to answer to us. And of course, the question then is, and how can we do that? It's easy in the one-to-one case. I can answer to you and you can answer to me in our conversation. But how do we answer collectively to the defendants who suffered injustice? Could this be part of the trial itself? It's not clear how that would fit in. All I say is that we need some kind of forum, some way in which we can recognise publicly that we must answer to those we've treated unjustly, if we've got them to answer to us. Of course, we anyway should address the injustice collectively, just because it is injustice. But still, if we're to preserve a system of criminal law which calls to account those who commit wrongs, in a context in which social injustice is also prevalent, we must find some way of recognising publicly that just as we call that person to answer to us, we must answer ourselves to those whom we fail to treat with the respect and concern due to them as citizens. And that's the further challenge we face in making criminal law, making the ideal closer to something that could be real, and finding how we can preserve criminal law as a matter of calling to account in the context of social injustice. How can we recognise ourselves as answerable collectively to those who have suffered injustice at our hands? So the overall message then is that I think we have this, what I hope I've said enough to show is a plausible, or at least attractive ideal of criminal law as a law fit for citizens. A law which takes seriously the fact we're dealing with each other as fellow members of a community. But the ideal is a very long way from where we are now. Some would say it's so far away it's simply a philosopher's fantasy. It's utopia in the pejorative sense. I hope that's not true, that it still has some resonance for us. We can see, certainly in its light, just some of what's wrong with our existing practices. It serves as a critical standard, but also as an ideal towards which we can begin to aspire to work. But how we work towards it, how we begin to make the ideal not actual, but even how we begin to make the actual closer to the ideal, I've tried to indicate the challenges we face in trying to do that. And I leave you not with the solutions or answers, but with those challenges, which I hope you recognise as serious ones. Thank you.